Good morning. Now that it's officially 10 o'clock, I welcome everybody to an oral argument session before the 5th District Court of Appeal. I'm Judge Jim Edwards. I'm joined by Judge Eric Eisnagel and Judge Jordan Pratt. First, I'd like to thank counsel for being flexible. We had something truly come up last minute that necessitated the Zoom or virtual oral argument rather than in person, and I appreciate you all being able to accommodate us on that. We have one oral argument this session, and that's case number 21-2985, Grace Ann King versus the state of Florida. I know you all have argued before the court in person and virtually, so you're aware the clock is in one of the squares there. We typically allot 5 minutes for rebuttal. If you want something other than that, Mr. Ufferman, you let us know and we'll give you whatever you request as long as it's less than 20 minutes. If you have noisemakers, please turn them off or turn them to mute. And as I always tell everybody, don't turn your cell phone off necessarily, because if we lose you on Zoom, we will call you and get you back on. And your cell phone is usually the lifeline we call. So with that, Mr. Ufferman, you let us know what you want for rebuttal time, and then you have the floor.
Thank you, Your Honor. Good morning. Michael Ufferman on behalf of the appellant Grace King, and I'd like to reserve 5 minutes of my time for rebuttal. I'm hoping to focus my time this morning on the first claim raised in the briefs, but of course I'll answer any questions that the court may have regarding the remaining claims. The first claim concerns whether the trial court erred by denying the second motion for mistrial after the state in closing improperly asserted that there was no evidence that my client had a prescription for Xanax. Now, whatever idiom you would want to use would apply in this situation. The straw that broke the camel's back, the error that improperly tipped the scales in favor of the state, they all apply under these circumstances. The comment alone would require a mistrial, but certainly when you consider the comment in the context of the entire trial, there was no way that my client could receive a fair trial at that point in the proceedings, and a mistrial had to be granted. I know the court is aware of these facts, but let me just give a brief background. The state's theory in this case was that my client's combined consumption of Xanax and alcohol made her impaired. The state put on a couple experts, but one expert in particular, Dr. Goldberger, who was asked to review his file and talk about what he found when there was a drug screen that was conducted. And Dr. Goldberger not only mentioned that he saw Xanax in my client's system, but also mentioned 2 other controlled substances, and then ultimately mentioned cocaine. Immediately when Dr. Goldberger said these things, defense counsel moved for a mistrial. And this was about 4 o'clock on the afternoon of those proceedings. The jury was excused and the trial court started to address this. The trial court ultimately let Dr. Goldberger finish his testimony that day and said that he would take the matter under advisement the following morning and decide the following morning about a mistrial. Not coincidentally, in that time frame, clearly in response to what Dr. Goldberger had said, one of the jurors, juror number 15, asked a question, and the question began with, and I quote, "I did not realize the extent of drug use." And that particular juror, we know her husband is a pharmacist. She had previously worked in the pharmacy, and she had indicated that she wanted to check her database to see whether or not either my client or the decedent were in the system back then. Now, obviously, she wasn't checking her database for cocaine, and she wouldn't have been checking the database for the drugs in the decedent's system, the methamphetamine. She would have been looking for these other drugs and Xanax, as Dr. Goldberger mentioned. Following morning, the court took about
Counsel,
2 hours, a little more than 2 hours to resolve.
Counsel, was
Yes.
she attempting to conduct her own investigation into the case, or was she attempting to see if she had some conflict as a juror that needed to be disclosed, because perhaps she wasn't sure if the defendant perhaps was a patient? Perhaps she didn't know if that created a conflict. Those seemed like 2 different things. Which one was it?
I think it's the latter. We don't know for sure, but the parties in the trial court all assumed that it was the latter. But it certainly, regardless of that, highlights how improper the trial or the prosecutor's comment during closing argument was. It's hard to fathom how, after you have a case where the judge has declared a mistrial, determined that no curative instruction could fix the jury being exposed to these other two controlled substances and cocaine, that a prosecutor in closing, knowing that there's a juror that asked this question and even wanted to go back in and look at a database, obviously looking at a database to see whether there's prescriptions, that this prosecutor would come back in closing and then say, there's been no evidence that she has a prescription for Xanax. Now, the
counsel, you're building your second motion for mistrial on top of the first one. And when the judge offered it and defense counsel apparently urged Ms. King to take it, and she knowingly, affirmatively, whatever, I mean, that may be for another day, but from everything we could see, she very much wanted to go forward with the trial. She must have thought this was a swell jury and all the rest of it. That motion was never renewed. You cited a case from wherever, Texas, North Carolina, wherever it was from, where the defendant was offered a mistrial, passed on it at first, and before trial resumed, had changed his or her mind and wanted that same mistrial on the same issue, and that was declared to be an error. But are there other cases where, you know, you pass, you go, never mind, we're fine, forget about it, let's go on? That's the case I want to hear about.
Well, I've cited numerous cases, and you're right, Your Honor. And let me explain why I cited that case. I think the point is this: the state in their answer brief, and I spent a lot of time providing the court with the background regarding Dr. Goldberger's error and the way that was handled, and the juror and the question. And then I said, and with that background, the second motion for mistrial was made after the clearly improper comment during closing argument. The state in its answer brief wants to pretend as if all the things regarding Dr. Goldberger didn't occur. And the case law in Florida is crystal clear that when this court considers a motion for mistrial, you must consider the entire context of the record. So you aren't only considering the final comment. Now, that final comment alone, for the reasons that I've argued, it's burden shifting. And again, it's an uncharged crime. So it's clearly prejudicial that would require a mistrial. But again, when you consider the entire context of the trial, there's no way that my client could receive a fair trial with that background.
Counsel, considering the entire context, I went back, of course, and looked at the transcript, and it seems like, as best I could tell, both sides at different times during the trial asked various experts, more than one, I believe, about the drug and using it, quote, as prescribed. And there were some thoughts throughout the trial that perhaps that if this drug was used on a regular basis, that one would not become impaired by it. Sort of, you become I don't know what the word is, right, but immune to it or whatever. You become acclimated to it. And there was never, I couldn't find an objection before to when either side discussed this drug and using it as prescribed or a prescription. I think once was actually said. So I guess I just I'm not entirely sure I understand why the state's limited reference in closing was, as you say, clearly improper, when both sides seem to raise this concept of using the drug as prescribed or a prescription throughout the trial without objection.
Well, because again, everyone agreed that there was a therapeutic level in her system. And the question was, and there was this discussion of maybe some people take it for sleep aid. Would that be what it's necessarily prescribed for? I understand that context. And there can be an argument about, was she taking it as a sleep aid or did she take it the night before, or did she take it that day prior to the accident? And that would that have impaired her that day? But the statement from the prosecutor specifically, there's been no evidence presented that she had a prescription for, and I'll say Xanax. That's clearly asserting to the jury, again, a jury that has someone that previously worked in a pharmacy, right, that she improperly possessed Xanax, didn't go get a prescription, and therefore that's illegal.
I guess that's what I'm asking is, given the context here, given the discussion about using the drug, let's call it Xanax, it's easier to pronounce, right? Using it as prescribed on several different occasions, not even just two, I think it was even more than three on different experts. The implication, as I understood it, as I read the transcript, was that, hey, look, if you have a prescription for this and you're using it regularly, which, by the way, if you have a prescription, one might there might be an inference that you're using it regularly, that it wouldn't have any impact on driving. And that seemed to be sort of the back and forth. And there was never an objection that I saw during the trial, even when there was this discussion on both sides by both lawyers with various experts about a prescription and whether it was used as prescribed, the inference being, again, that it's used regularly. So I guess given that context with no objection, and when it's being discussed by both sides with multiple experts, I guess I just wasn't, why should we be surprised that the state references, but hey, by the way, sure, maybe if you use Xanax regularly, you might not be impaired, but gee, there's no evidence of a prescription here. They didn't say there was no prescription. They just said, hey, like you don't have the evidence to conclude that this was used regularly. Why isn't that what was happening?
If they would have said you don't have evidence to conclude this was used regularly, there wouldn't be a problem. But what they specifically said is there's no evidence that she had a prescription. It would be illegal if she used Xanax without a prescription. That would be a crime that the state could have charged.
What if they had said in closing something slightly different? What if they had said, look, you've heard various testimony from more than one expert regarding regular use and whether or not use as prescribed might reduce impairment to the point that even a driver wouldn't be impaired at all. But members of the jury, I submit to you, there's no evidence that there was a prescription here either way. If they had said that, is that a problem?
Yeah, again, it's a crime for her to have Xanax in her system if it wasn't prescribed. If that's what the state was asserting, they could have charged that, and my client could have defended against that. She could have presented the prescription. But to get up in closing for the first time, again, for putting aside the burden shifting argument, that if the state has evidence that she didn't have a prescription, by all means, put on that evidence. But don't tell the jury that she has some burden to put on evidence that she had the prescription. And again, she clearly wouldn't put on that evidence because it wasn't charged.
You have multiple experts. And by the way, both sides. I mean, I think it's interesting that both sides initiated this discussion with the experts, that use of the drug as prescribed or regularly using it. And I think the inference was as I read the transcript, the inference was when you use it as prescribed, you don't become impaired. Right?
Your Honor, if you disagree with me that there's no fair reading, no possible reading of there's been no evidence presented that she had a prescription, that would mean that the state's asserting that she didn't have a prescription. And a jury any juror, in particular, a juror who used to be a pharmacist, would conclude that that's also illegal. She has Xanax in her system because she doesn't even have a prescription for it. That's another crime.
All I'm saying is I read the transcript. I went back and tried to find every point where this was discussed and tried to review it more than once, maybe more than twice, to get a sense for what was happening instead of just looking at the closing argument in isolation. And so what I'm asking you is, given the back and forth about using the drug as prescribed with more than one expert and both sides initiating it with the experts, what comment on the as prescribed or prescription, what comment would have been fair for the state to make? Is it your position that despite all of that discussion before the jury, that they couldn't reference a prescription at all?
Yes, that's what couldn't reference a prescription. The therapeutic levels and whether she was using it the night before for a sleep aid or used it that day. Again, if the state believes that she was not using it as prescribed, that's one thing. But if the state also believes that she used it without a prescription, that's completely different, because the latter is a crime. And again, I've cited the cases in my briefs. My client had a due process notice to any alleged crimes that were going to be brought up in this case. If they didn't charge.
If your client had introduced, let's say just theoretically, your client introduced evidence of a prescription. Hey, look, I have a prescription for this. I use it every day. Here's let's just say that evidence comes in. Is there an inference then that, let's say there's just the prescription. I have a prescription for this. I've had it for the last year. Is there an inference? Can the jury draw an inference that it is used regularly and therefore may not have contributed to impairment?
Sure, in that situation, but those aren't the facts of this case. Right. The facts of this case is the prosecutor, for the first time in closing, is telling the jury that she didn't put on evidence, or there's been no evidence presented, but the state's the only one that has burden to prove that, but that's not what the state was saying. Therefore,
I think we understand your argument about closing. I just wanted to ask you a brief question before we get into your rebuttal time about the last issue that you addressed in your briefing, where you assert that there's a DCA conflict on the necessity or not of specifically citing the local ordinance that authorizes costs. Could you just, and it could be a very quick answer, could you point us to the substantive source of law that you believe imposes that citation duty on the trial courts? Is it a statute, or are you saying that it's a due process notice type issue? If it's a statute, can you give us the citation to the specific provision that requires citation to the local ordinance?
I think it's a notice issue, and I think the courts that have addressed this have said that this is a statute that is not self-fulfilling. It requires that the local government act to allow for this cost to be imposed. And therefore, if the local government has in fact acted, then the legislature has said that upon the local government acting, then this cost can be imposed, but it cannot be imposed unless the local government is active.
Okay.
And
But
therefore,
I understand that you must have a provision that authorizes the cost. But as I understand the question that you've posed, it's the question whether the trial court, even though it has a local ordinance basis for imposing the cost, that it is nonetheless error for the court to impose the cost, having the authority to do so, but to fail to cite the ordinance.
That's what, yeah, I agree. That's technical over substance. The question's got to be, in order for this cost to be imposed, there must be a local ordinance that allows for it. I'm not sure that there is a local ordinance. I practice statewide. I'm not familiar with every single county's local ordinances. Okay. So therefore, what courts do is in their judgment, they cite the state to the local ordinance.
If the state, in her time, points us to the ordinance that allows this cost, then you would concede that it was not error. Okay.
Correct. Let me go back and address, again, make a couple of final points into my rebuttal time. There's no question under Florida case law that this must be looked at from a cumulative standpoint. I've cited case after case that says that. So the reason I cited to the California case was arguably Ms. King could have come back and said, I want to reconsider whether I waived the previous mistrial. And there's a court that's allowed that. But in this case, she's the one, and maybe the only one, that said, I'm ready to go forward. This trial was delayed from COVID. She was in custody during that time. So in her mind, look, even though the judge previously said there's no curative instruction that can fix this, that's the exact quote from the judge. And he was already considering this idea that we're going to tell the jury that they can disregard, maybe Dr. Goldberger was mistaken. I submit, if you look at Dr. Goldberger's testimony, there's no reasonable way that the jury really believed he was mistaken. He was reading from his report. And so the jury would have had to have believed that he was somehow reading from some different report that not only involved alcohol and Xanax. I've, having done hundreds of cases throughout my career and clerked at the Florida Supreme Court, I've never seen another case where DUI manslaughter was based on both Xanax and alcohol. So nevertheless, the Ms. King is the one that decided, I'll still allow this to go forward. But now in closing, they're going to get up, and in addition to everything that's already happened, and we know that we have this juror that has his pharmacy background, they're now going to tell the jury that there's been no evidence that I had a prescription for Xanax and insinuate that I've committed another crime in addition to maybe having cocaine, maybe having these other drugs in my system. Now I've committed another crime because I didn't put on evidence that I had a prescription for Xanax. That's the straw that broke the camel's back. There's no way she could receive a fair trial. If you conduct a cumulative analysis, that's why my client's entitled to a new trial. I'll reserve the rest of my time for a rebuttal. Thank you.
All right. Thank you. Ms. Davenport, you're up.
May it please the court. My name is Chris Davenport, and I represent the state of Florida. Let me just start with the last issue because I think it's relatively simple. The trial judge, in ruling on the 3800B filed by a defense counsel, cited the local ordinances, so we know they exist. And this is a form over substance argument. And as far as notice,
if I could push back a little bit on that, I have had, obviously, on my time on the bench, I have reviewed many of these cost orders, including local ordinances. And let me ask you this. How do we review the imposition of a cost when it doesn't have citations? I oftentimes find it difficult, if not impossible, to review the appropriateness of the cost that's imposed. So what am I missing? How do we do? In other words, isn't there some sort of due process issue here where if a trial court just imposes a random cost, but we can't review it because we don't require citations? What do you think of that? How do we get around that? Maybe I'm missing something.
I think of that is the defense burden to at least allege that there is no such ordinance out there. And there's no allegation of that here. It's just it's been a form over substance kind of argument. If they don't believe there's an ordinance out there, they should allege that in a 3800B and then, put some burden on the state or the court to find one. The local courts.
Would it be enough to simply allege that, not affirmatively that there isn't one, but hey, look, we've thought about it. We can't find one. We're not sure. Would that be enough?
I think if they said we've looked and we can't find it, that would be enough. But to say that every single one of these orders is invalid because it doesn't cite the specific local ordinance, I don't know where that comes from. That's not in the statute. It's not a statutory requirement. And courts have always operated under the principle that the citizens have notice of what's in statutes and
right. But I mean, the problem is these oftentimes these costs have the same amounts. You can't just assume that because you see a $2 cost or a $65 cost or whatever, you can't just assume that, oh, we know for sure what it is. And sometimes once in a while, what if you have a case where there's a $65 cost that would be appropriate, but a $65 cost that is clearly not, right? I mean, you see the problem when we don't have this. And also then you have Anders cases where counsel has essentially failed to identify anything, and we have our own obligation to review the record. Perhaps does that create a different scenario then when counsel isn't being relied upon to raise an objection?
I think to preserve this, you have to file a 3800B. If they haven't filed one, it's not a preserved issue and it's not.
But in Anders cases, we have to do that review. And this court routinely sends it back and says, hey, what about this error? Why shouldn't you file a 3800B?
Right. And then defense counsel can either say, yeah, I'm going to do that. I'm not aware of any ordinance. I've looked, I can't find an ordinance justifying this, or, well, we know there's an ordinance, so we're not going to file one. There should be some burden on the defense to, there's a burden to preserve the error. There should be a burden to say, this is an invalid cost, not because he didn't cite the ordinance, but because.
So do we need to go en banc and, in your view, recede from Chavez, or what is your position on that? Is
Chavez a case out of the fifth? That's out of the fourth, right?
Well, maybe I got that. Maybe I have the wrong name. I'm pretty sure. I believe the fifth has in the past on several occasions ruled that you have to have citations for each cost so that we can review it.
I am not aware of a case out of the fifth saying that a local ordinance is required to be cited under these statutes.
We do, Ms. Davenport, we typically say it's got to have a citation to a statute.
Mm-hmm.
And so if the statute requires an underlying ordinance, seems like the logic is there. If we require a statute in the first place, if the statute says you can have the money if there's an ordinance and no ordinance is cited, I mean, it seems very consistent to require the citation of the ordinance.
Well, what the court has said is you don't need to cite the statute as long as the cost itself is specific enough that it provides notice. So we know what we're talking about. They can't just say $2 or $10. They can't just randomly throw costs out there. But they can say, $2 from a routine court fund was a big issue for a long, long time. And they didn't have to cite the statute. They had to say $2 routine court fund. So there is no requirement to cite the statute. There's a requirement to give notice where we're getting this from. And we would submit saying we're getting it from this statute is ample notice. And if the defense believes that there's no local ordinance citing to the activating the statute, then they should say that. I would note here that, again, the judge did rule on 3800B in an untimely fashion. So his ruling is a nullity, but he cited the local ordinances. So we know they exist in this case. And remanding is, it's just form over substance. Nothing in that. If that statute had said the county has to enact an ordinance, which is cited in the order, I think we'd have a totally different situation here, because then we would say this is only valid if it's cited, but that's not what's happening here.
So I understand that's not what the statute says, but it sounds like you're conceding that there's some minimal due process requirement of notice so that, the other side can understand what the basis for the costs are. And if they oppose, the authority for the cost, they can go ahead and present an argument, right? It sounds
that's
like
exactly,
you concede as a matter of due process. Okay.
It's just a matter of, do you have to cite the local ordinance to give that due process notice? And we would say no, that this was specific enough here. Everybody knew what it was.
Let's talk about prescriptions for a little while.
Okay, let's talk about prescriptions. As was pointed out during the defendant's argument, the fact that this was a prescription and therapeutic amounts and building up a tolerance for Xanax was presented by both sides throughout the case, because everybody agreed she had Xanax in her system. The question is, how much did that affect her level of intoxication? So there were, competing experts, but everybody agreed relatively what the amount was. And everybody agreed that if you take this all the time, you develop a tolerance for it and it wouldn't affect you as much, which is kind of a common sense thing. When the state made its comment in closing argument, she explained when the mistrial motion was made, that's what she was talking about, was this therapeutic level. And if you take it to sleep, it would be kind of out of your bloodstream by the time of this accident, and how that all worked. That's what she was talking about. Did she technically misspeak and say, there's no evidence presented? And, that's an awfully fine line to draw there. If she did misspeak, the trial court, who was there, who heard it, who saw the jury's reaction to it, specifically made a finding this was isolated, this was inadvertent.
So on that, counsel, your friend on the other side contends that our precedent is once there's an error in this fashion, uncharged conduct, then our precedent in Botto and Fike presume that the error is harmful, and then the burden shifts to the state to prove that it's not to prove that it's harmless. You can see that that's the standard.
I can see
pushing back against that.
I don't agree that that's what happened here. I think the fact that that the prosecutor was talking about the prescription wasn't in the context of an uncharged crime, where those kind of things come up, where it's pretty obvious that the prosecutor is talking about something that, they molested another child, or this isn't his first burglary or anything like this. This is context of talking about prescriptions. It's not the first time we've heard about prescriptions in this trial. It's throughout the trial. They were talking about that the whole time. It's in the context of prescriptions and therapeutic use and whether or not she had a tolerance.
And that's an argument that it's not, error, right? But if we get to the point where we disagree with you on that and we agree with your friend on the other side and say, well, this is error, maybe it's a small error, maybe it's just a little blip on the radar. But if we get to that point, you can see that then the burden shifts to the state to show that it's harmless. And if so, what's your best argument that any error here is harmless?
I think it's not our burden to prove it harmless. It's their burden to prove that the mistrial should have been granted. Harmless error has nothing to do with a mistrial, because if it was so prejudicial that it vitiated the trial, that's what they have to show to say the trial court should have granted a mistrial. That's their burden. That doesn't shift to us. So the issue on appeal isn't whether or not this comment was erroneous. The issue on appeal is whether or not the trial court should have granted a mistrial.
So it sounds like there's a disagreement then between both sides about whether this generates a sort of presumption of harmful error. And I understand that. Can we, and I see that, we're about 5 minutes away from your rebuttal time. I wanted to give you a chance to address the photos as well. Do you have a case that you can cite to us that stands for the proposition that the state is entitled to introduce photos of the decedent where the cause of death, the location of death, the fact of death are not disputed in the case? Do you have a case that you can point us to?
I cited cases in my brief that talk about the fact that you stipulate doesn't mean that the state doesn't produce evidence. That's not how that works. The state still has to prove all the elements of the crime. One of the elements here was that the victim was killed in this accident. And I cited numerous cases where they presented evidence about the victim's injuries, that a single photograph of the victim found at the crime scene is relevant to show how her body appeared, because we have to show that, the victim died at the crime scene. There are several cases in my brief. I rely on those as a whole. There's nothing specifically in this context. The closest case that the defense cites is the Connor case. I know they rely on that pretty extensively. The Connor case, the problem with that photo, the court didn't say you can't introduce a photo of a dead body. The court, because that would be absurd. You have to introduce that. We have to show a dead body. This is a homicide case. It's not a shoplifting case. What Connor involved is the way they used that picture is the court kept saying, see, this shows where he was hit. And the prosecutor kept saying that. What the real issue was, where he was hit, not where the
Counsel,
body.
when you say you have to introduce the photograph, I'm not sure that's correct.
You're right. I misspoke there. They don't have to, they get to. How about that? You get to produce, your case. You can support that to the jury. The jury needs to know, here's what it looked like at the scene. We have a bunch of pictures of the truck and you showed how smashed up it was. Here's the victim lying there. I mean, that's all part of the state's case. In a homicide case, we have to show that the victim was dead. And this is one way to do that.
Let me go back just for a second for the prescription closing argument. The judge all but asked the judge did ask if the defense wanted anything further besides arguing for a mistrial, which to me I take as an invitation to ask for curative instruction, and there was no request. Does that matter?
It doesn't matter for preservation, but I think it's something to consider. It was this issue was preserved. All they have to do is move for mistrial. They don't have to request a curative instruction. I think the judge thought if this was really a problem, we can certainly address it here. And the defense didn't want to do that for whatever reason, maybe because it was such a brief and isolated comment that they didn't want to call attention to it. But the judge was there. The judge saw the jury's reaction to this comment, and the judge saw it in the context the prosecutor was making the argument. So this isn't a case where she said, but by the way, we could have charged her for not having a prescription for Xanax because the defendant didn't show that she had a prescription, but we were kind and only charged these offenses instead. If she had said something like that, that would have been pretty prejudicial, but that's not what it was. In the context, it was a discussion of how this all works in Xanax and intoxication, which was, again, a pretty big part of the trial. Let me also briefly address the cocaine issue. The trial court found that was prejudicial. The trial court said, I'm going to grant a mistrial at the defendant's request. This is too prejudicial. The defendant herself said, I don't want to do that. I want to keep going forward. She waived the claim specifically. The judge went through an extensive colloquy with her and said, are you sure, your attorney doesn't think this is a good idea? Did you really get a chance to talk to him? Yep, I'm sure. You know that you're going to waive this claim. Yep, I understand that. You know that you can't claim your attorney was ineffective on the basis of this claim. You can't raise this as an appellate issue. Yep, I understand this. The judge did a really good job making sure that the defendant made a knowing and voluntary decision here. And ultimately, it's her case. She's the one who's going to jail if things go bad. It's ultimately her decision. She wanted to waive it, and she specifically did. She also specifically said during that colloquy, we've decided on a curative instruction. Do you agree that this is going to cure it? And the defendant said, yes, it does. This cures it. I'm happy with this instruction. And I have to say, this is one of the better instructions I've ever seen. It kind of called into question the testimony of the state's expert, because it basically said he was confused. He wasn't reading the right case. There was no cocaine in her system. It was just alcohol and Xanax. And he made a mistake, which is why I stopped everything. But you can't consider that because, he screwed that up. I'm kind of surprised the prosecutor agreed to that because it made their witness look pretty bad. But the court, mitigated that by saying, look, you can't use this against the state's expert because we all know that, that's not what really happened here. And you can't take advantage of this. And the defense didn't. But this was a really strong curative instruction that the defendant herself agreed cured the error. And once you agree to that, you can't come up and say it's part of cumulative error. This isn't an unobjected to error. This is an error that everybody knew about and the defendant affirmatively waived. You can't, that cleared the board. You can't bring that up later and say, well, I know I could have had a mistrial. But I declined that. But from now on, everything has to be perfect because, boy, we got this error floating out here. That's not how it works. That's not fair. They waived it. it can't be considered as part of cumulative error. And certainly, as I pointed out in my brief, this is pretty different error, saying, you know, prescription for Xanax, which everybody was talking about, is a whole lot different from saying, by the way, we found cocaine in her blood and her urine as well. That's obviously more prejudicial. Again, the judge who was there said, oof, we need to do a mistrial. They decided not to. She lives with the consequence of that. It was her decision. That's certainly her right, but she can't take advantage of it now and say, oh, it's part of the cumulative error. That's not fair. That's not how it works. You can't have this sword hanging over the state's head and make that hang there by declining a mistrial. That's not fair, and it's not part of cumulative error. So the only issue here is a single isolated inadvertent comment that the trial judge was there for and said, you know, let's just move on. I sustain the objection and we'll move on. And they did. The prosecutor never mentioned anything like this. We're talking about one bad sentence in a 27-page argument, which when you look at it in the context, maybe she misspoke. It certainly wasn't so prejudicial as to vitiate her right to a fair trial, which is what the defense has the obligation to show on appeal. So given that, unless the court has other questions, we would ask you to affirm the judgment and sentence. Thank you.
All right, thank you very much. Mr. Offerman, your turn to disagree violently, vehemently.
Thank you.
Not violently.
May it please the court, you took the words out of my mouth. I do vehemently disagree with my friend, Ms. Davenport. She says this cleared the board. Let's start with that. This has to be considered in the context of my client's mind. She was willing to move forward, yes, with a curative instruction that the judge himself had already said could not fix this issue. But nevertheless, she agreed to that. That doesn't erase it. And it also doesn't erase it in the minds of the jurors. So now fast forward, we get to closing argument. We know we have a juror with a pharmacy background, and a prosecutor chooses to tell the jury there's been no evidence that she has a prescription. That's immediately going to send off red flags in the mind of that juror and every other juror. Oh, she's committed another crime. She didn't have a prescription for this Xanax.
Mr. Offerman, the question really here was, how much did the Xanax affect her? And there was all the discussion by the different people of, if you took it on a regular basis as prescribed, so on and so forth, you would build up a tolerance to it and therefore not be as affected. And her blood alcohol, according to the defense expert, was like a 0.06. And if she had a tolerance to Xanax, then, you know, the other experts are saying, well, driving 90 miles an hour without a headlights, that's not consistent with being drunk. The jury could have rejected that regardless of any prescription testimony, couldn't they?
But Your Honor, the prosecutor told the jury she committed another crime. I'm not.
No, not exactly. They talked about whether there was a prescription or not, which had been referenced and discussed, whether she was taking it as prescribed over time, therapeutic doses, all the rest of that.
A fair reading of this is that the prosecutor referenced to the jury that she hasn't put on evidence that she has a prescription. If there's no prescription, it's a crime. And this isn't some made up after the fact argument. It's what defense counsel himself immediately argued when the comment was made. So this idea that everyone else is interpreting in some other way, Mr. Stone clearly and immediately interpreted as, oh my goodness, this is an uncharged crime. And how is this jury going to take that?
How does the state address the numerous, just tell us how the state should properly address the numerous references to using it as prescribed that were raised not only by the state, but by the defense as well with multiple experts? What's the proper way for the state to say, hey, look, they've made a big deal of, using this as prescribed, but there's no prescription in evidence. How do they, or do they have to just let the jury maybe think that there's a prescription and go with that argument? Is there
they have to, because they didn't charge her with not having a prescription. It's a crime, and it's a crime on a case where you have a juror who has a pharmacy background who's going to look at her database.
Counsel, hold on. Would your argument be a lot stronger if defense counsel hadn't engaged in this sort of discussion with the experts throughout the trial as well? There was no
insinuation during the trial that my client committed another crime by not having a prescription. That's the problem with this argument. When you tell the jury that she's committed another crime, and you do it in closing argument when there's no opportunity to respond with any evidence.
What was the relevance
when you combine that?
During the testimony, what was the relevance of asking multiple experts about whether or not Xanax will impair someone who is using it regularly as prescribed. What was the relevance of that line of questioning?
Because I think we have a hard time in science to combine alcohol effects and drug use. If it's just alcohol use, we can do a retrograde extrapolation and say you're either over the legal limit or not. But in this case, even their own expert agreed that the limit could be 0.06, which would be under the limit. That's what the defense expert said. So now you're trying to figure out, how does Xanax apply to that? And we're talking about its therapeutic level, so it's not beyond what would normally be prescribed. That's all fair game. But to then get up in closing and actually tell the jury, maybe she doesn't even have a prescription.
No, actually, it was
for this.
specifically, this discussion was specifically the length of time it's being used, not just that it was used once therapeutically, but that it was
That's
used
fine,
over.
but I must be missing it, and Mr. Stone must have been missing it, because the prosecutor told the jury that you don't have, she may not have a prescription.
I'm just asking, what's the relevance of talking about prescribed use over time during trial with multiple experts?
That it wouldn't have had an impact and wouldn't have caused her to be impaired, and therefore she's not guilty.
Okay.
But that has nothing to do with whether or not she committed a crime by not having a prescription.
Mr. Efferman, doesn't an expert's testimony have to be based on evidence? And isn't the prosecutor allowed to say there was no evidence of a prescription here?
So how does that play out? So the numerous records I reviewed, the first time this would have been brought up, a prosecutor would have said, "Judge, I need to go to sidebar. The defense is getting into something that it's going to cause some problems down the road. I don't know if they put on any evidence that she doesn't have a prescription. We haven't charged her with not having a prescription, but we need to deal with this." And you deal with that, so both parties can have some input. And so you're not being surprised for the first time in closing argument with the statement, "There's been no evidence presented she had a prescription." That's a crime. The juror who worked for a pharmacy would have known that's a crime, and therefore for the first time in closing, that's being alleged. When you combine that with cocaine, it clearly tips the scale. So there's no way my client could get a fair trial, and that's ultimately the question. If this court, and I've raised the cumulative error argument,
And
if you step back and you say there's no possibility,
We're beyond your time now, so we thank you very much. We understand your arguments, both sides, and well presented. We'll be in recess. Thank you.
thank you, Your Honor.